Hi, everybody. Thank you so much for joining me today. My name is Michelle Morris, and I am with Consolidated Planning Group. We have a fantastic educational webinar for you today. We're going to be talking about why it is so important that you have an attorney who focuses on special needs on your team, and you also have a financial advisor who focuses on special needs planning. It is so important that you truly focus on making sure that you have experts in your on your team helping you plan for the future for your loved ones, because there are things that are very important and very nuanced. And when it comes to special needs planning, you want to make sure that you take advantage of all of the good benefits that are available out there to you from the state and the federal government, and that you don't jeopardize any of those benefits by making bad decisions or incorrect decisions. And there are so few financial advisors and attorneys who truly focus on this and understand those little tricks of the trade, that you could end up spending more money to fix issues than if you had just gone with a true professional in the first place. So today we're going to be talking about that. Before we jump into the conversation with Leona Filis today, the attorney that we've brought in to help us discuss this, I just want to go through kind of the rules of the road, and then I'm going to talk a little bit about Consolidated Planning Group, and then we're going to get going. We should be here for about an hour today. We usually run our webinars from noon to 1. So plan to be here for about an hour. If you want a drink or a snack, that's cool, because we cannot see you or hear you anyway. Since we are in webinar mode, that means that all of your cameras and all of your microphones are muted. And if you want to let us know anything, questions, comments, you can put those all in the chat box. I'm going to be watching the chat box as we go through, and we will get to as many of those questions as possible. And I know that some people sent in questions when they registered, so we have those as well, and we're going to try and hit on those as we go through. This is being recorded, so if you have to step out, you will receive a link to the recording later on today in your email. Spoiler alert, it will go onto our YouTube channel, just like all of our other videos and webinars do. So, who am I? Who's Consolidated Planning Group, and why should you be listening to us anyway? First of all, let's tackle that question. Consolidated Planning Group is a holistic financial planning firm. We focus on all the areas of your financial future, but we look at them through the lens of understanding that if you have a loved one in your life with some kind of intellectual or developmental disability, they might not be able to take care of themselves for the rest of their lives. They're going to need support. They're going to need financial help. They might not be able to be completely independent or hold a full-time job. So as a parent, it's kind of your job to make sure that there's enough funding for them to get through their life and to have that help. So we help families all across the United States focus on planning for their future, but also through the lens of understanding that they have to think long and hard about their family members' future as well. Now, even though we're located in Houston, we work all across Texas and all across the United States. Some of the topics that we talk about in our webinars are Texas specific, but many of the topics that we cover would be the same nationwide. And it's fine with us whether you live in Illinois or Pennsylvania or anywhere across the United States. We can certainly help you. We have over 30 years of experience in the financial services industry. That's, life insurance, investments, securities. We are completely licensed and certified in all of that. We also take our education further by getting additional licensing, like through the Special Needs Planning Academy. We are chartered special needs consultants, and we are nationally certified as social security advisors. So we take this very, very seriously. And it's not just, once in a while we have a client who has a loved one with a disability. It's like 90 something percent of the clients that we help have children with a disability. So families really come to us for things like protection plans for their whole family, lifetime care planning, transition planning. There are a lot of big transition periods in our children's lives, and it takes a lot of thought to make those happen smoothly and successfully. We can help you with ABLE accounts and understanding how to use them. And of course, we are here to help educate you and to advocate for you. There are over 263,000 financial advisors across the United States of America. But out of those 263,000 financial advisors, fewer than 200 focus on special needs planning. That's less than 0.1% of all the financial advisors in the United States who know those nuances the way that we do. So you are really in the right place. So families come to us and things that we want you to think about, because we know it keeps you awake at night. You're probably laying there in bed worrying, just like most parents, but a little extra in your case. And you're thinking about who's going to take care of your child when you can't do it anymore. And that's exactly why you need both legal and financial help from experts like Leona and Consolidated Planning Group. So we want you to think ahead of time. Right now is the best time for you to start planning for the future. You can't go back in time and start your planning, last year. So you have to start now, right? We want you to think about what's going to happen after high school. There are residential options, there are vocational options, there are, summer programs and day programs, and even vocational resources that can help your children. But you need to get on the ball and you need to be looking for these things ahead of time to make sure that if there's a waiting list, you're on that list. And then we always say to be very, very careful about just thinking that a sibling is going to take care of your loved one. Siblings are great. They love each other. They want to help. But when the time comes right down to it, we've had a lot of meetings where the sibling is kind of resentful that mom and dad left them to take care of one another. And both siblings feel this way. The sibling who is maybe the neurotypical, oh, you're going to take care of your little brother, Sarah, because you're going to have a job and a family and you're fine. You're going to be making money. So you can take care of your little brother, Jacob. Well, Sarah's got her own thing going on, her own family, her own career. She might see taking care of her brother as an obligation. And little brother Jacob, he's loved Sarah his whole life. They've been siblings, they've been partners in crime. And now Sarah is stepping into more of an advisory role or a parental role. And he might not like that at all. He might think, well, she's supposed to be my friend and my sister, not my mom. So he might feel some resentment. So it's just careful planning on both sides of that equation. So I do see that there are already some great questions in the chat box, and we will get to these, I promise you. But first, let's talk a little bit about the difference between what Consolidated Planning Group and other financial advisors like us versus Ms. Leona Filis and other attorneys like her can do for you when it comes to planning for your loved one. And Leona, do you want to talk a little bit about yourself and introduce yourself before we get into this discussion?
Well, I'm actually a parent of a child with autism, and
Mm,
I too had these same questions about how am I going to prepare for the future financially. And so with my son, it started. He's 16 now, almost 17. So it started a ways back, and and this has been something that I definitely have thought about. And frankly, there was not a lot of options out there, and I'm so glad to see that we have consolidated planning group and other resources now available to parents like me that we didn't have 15 years ago. So that's what started my journey. And then I did switch over from oil and gas law to focusing on helping families with children with special needs. So that's where we're at now. And we've been there for a few years. And that's what we plan on continuing doing as long as we can. We have a great staff. Everyone is very dedicated to the families that come and see us, and if we can't help them in some capacity, we find the experts who can, just like you.
yes, exactly. That's what we do too. We don't know everything, but we know who to ask in most cases. And we have gathered up those resources from being in the community for so many years. We keep lists of great people all across the nation who can help. So we help provide the financial advice, thinking about how you're going to pay for things and pulling in all of those considerations. And we do not provide any legal advice. We do not do any of that. Now, when we work with attorneys, we we don't work for them. They don't work for us. There is no referral fee. There's no kickbacks or anything like that. It's just another member of your support team. And we, through things like these webinars, we are able to meet a lot of great attorneys and kind of vet them and get to know them. And through listening to our clients and it's definitely very important that both of your bases are covered because we are kind of the money side of things. And Miss Phyllis is like the paperwork and legal side of things. So you need both, definitely. Um, so 8 steps to consider when raising a child with special needs. We're
So
gonna
yeah, that's what I typically like to talk to people about. And I know for our purposes here, we're gonna focus on the financial what we can do to help people with uh, with financial needs and financial planning needs. But the very first thing that I usually tell people is please put your child on the interest list for Medicaid waiver programs. First thing. A lot of people don't know what I'm talking about. And we also help people get guardianship over their adult disabled children. And so when we do that, again, my first question is typically, do you have your children on the Medicaid waiver program interest list? And when I hear no,
or the what?
when I hear no, then I'm just like, oh, so let's remedy that and let's make a phone call now, because there are services out there for your children. In Texas, there's like half a dozen programs, and half of those are administered at the state level, and the other half are administered at a local level. So there are a couple of phone calls that you as a parent need to make and get your child on these waiting lists called interest lists. But once your child starts receiving benefits from one of those waiver programs, you will, as a parent, get some relief depending on which waiver program your child has. Some relief in the form of respite, or Medicaid also comes with it, right? So you'll get financial relief. You'll have insurance from the state. Um, So these are things that you'll want to talk about. And this is kind of why we're doing these special needs trusts and why we're planning strategically with experts like consolidated planning groups so that we can make sure that we don't jeopardize our children's eligibility for government benefits like the waiver programs, like SSI and Medicaid.
So there are several questions in the chat box already about SSDI and survivors benefits. And so I think, that's a fine place to start. Do you want to go over, Phyllis?
Sure. So I don't handle SSI and Medicaid or SSDI cases,
Okay,
but
well, we know a lot about SSI and SSDI and how all of that works. So if you don't mind, I'll give a quick answer to these questions. So typically when your child turns 18, a little background here, if you don't mind, when your child turns 18, they can qualify for SSI benefits. They usually won't qualify for those benefits before they turn 18 because there are very low thresholds for income and assets. And they're going to look at the parent's income and assets if the child is under age 18. Now, as soon as your child hits 18, they're going to look at the child's income and assets only. So at that point, your child is getting SSI. It comes with Medicaid. Hopefully, they'll be on that for several years. And then when the parent turns on their Social Security benefits when they're in their late 60s, the child will switch from SSI benefit onto SSDI. They could also be getting that if the parent is disabled or if the parent has passed away. At that point, they're going to turn off SSI and switch on to SSDI, which is also called RSDI or RSDI. It's all the same thing, really. It's just that they have different names, which makes it very confusing. Now, so can my son be on SSDI and survivor benefits? Well, SSDI is the survivor benefit and HCS. HCS is one of those waiver programs that Leona was talking about. So yes, you can be on SSDI or some kind of other survivor benefit and HCS at the same time. Yes, SSDI is the same as RSDI. They've got a lot of different names for the same program. This next question says, if my son is on that survivor's benefit, does he have to still maintain less than $2,000 in his bank account? That's one of those really low thresholds that I mentioned. The limit is $2,000 in your bank account. You can have money in other places, but you cannot have it in your main bank account. And that can be an ABLE account or a special needs trust. But yes, you do still want to keep less than $2,000 because, SSDI doesn't have that limit, but what does is Medicaid, and you don't want to lose Medicaid because then you're going to lose the Medicaid waiver programs that will help pay for housing and therapies and medications and respite hours and all of that. So it is still very important to keep less than $2,000 in your checking account.
yes, definitely. Yep, I agree.
Perfect.
Because
So
they're not going to qualify for SSDI on their own. Some people think, well, when my child turns 18, I'll get them SSDI. No, they don't have the work history, but they can if they qualify as a DAC, a disabled adult child. And if their parent, like you said, is now receiving Social Security, then they can switch over from SSI to SSDI as a DAC to get that survivor benefits. But you still keep the waiver services and you still keep, what you can. You can, in some cases, still have Medicaid and eventually get Medicare. There is a waiting list to get on Medicare after you qualify for the SSDI, but you can have both in some instances. So that is a very important thing. One of the things I was going to mention in Texas is if you have, as a parent, you have employer provided health insurance, and you also have a dependent, your child, who has Medicaid. Look up something called the HIP program, HIPP. Health insurance is a reimbursement program for premiums. So if you have employer provided health insurance, you may be able to have free insurance for the whole family through this HIP program.
Yes, perfect. Thank you. And some of our children do qualify for their own um work records, their own SSDI if they work enough, which is great. If they don't work or don't work enough, though, they can still qualify under a parent's record. So there are different ways that you can get around to your child being on those benefits. It just depends how how much they work and if they work over the substantial gainful amount. This year, you're allowed to make $1,650 a month. That's the substantial gainful amount. If they make over that 1620 per month, then they won't qualify for SSI anymore, but they will be building their work record and their own Social Security work history, getting those credits. So, as financial advisors, we can help you with financial advice, thinking about retirement and saving for your own retirement, thinking about how and when to use your money and what the best ways are. Is it working hard enough for you? Financial advising can be fee-based or commission-based, or a mixture of kind of both of those strategies. And you want to definitely ask your financial advisor, if they're not upfront with how they charge you, exactly what the fees are, how they charge you, and how that all works. We can help you calculate your future cost of care estimate for your loved one to think about, do they need $1 million? Do they need 10 million? Is 300,000 going to cover it? What type of money are we talking here to care for our loved ones in their future? We can help you think about that. And we make sure that you have your assets kind of in the right buckets to protect that eligibility. Because as we've said, your loved one cannot have more than $2,000 in their bank account. So what happens if you pass away and your life insurance goes to your child and now they have $250,000 in their name? That can cause major, major problems. So we need to set all that stuff up ahead of time to be able to make sure that we don't jeopardize those other benefits. We can look at your ability to retire based on your current assets and your income and your expenses. Plus, are you going to be able to have a great retirement and then also pay for the future care of your loved ones? And we provide the best advice on what, financial vehicles are a good match for your goals for the future. I do see another question here in the chat box. Is the 1650 or 1620 $1,620 limit for money from your job or SSI benefits? So our children are allowed to make $1,620 a month at work. That is earned income is what they're talking about. So your SSI benefits does not count as income. And is it better to have wills or living trusts for parents to fund the special needs trust? What do you think, Leona, about is it better to have a will or a special needs trust? What's the difference?
Okay, well, for some people, it depends on whether or not they want to put all of their assets in a revocable living trust currently, or go ahead and take care of the transition of ownership of all these assets upon their death through a will. I suggest you first get a special needs trust for your child with a disability. And you use that and point to that special needs trust in all of your estate planning, whether it be a will or a revocable living trust. And your revocable living trust, so it depends on what you're trying, I guess your long-term goals. Are you trying to avoid probate? Then you'd want to have something like a revocable living trust. Some people think there's a tax advantage for inheritance tax by putting all their assets in a revocable living trust. But Texas doesn't have inheritance tax, and I believe it's you have to have over 13 or 14 million dollars of your estate to be subject to inheritance tax federally. So that shouldn't be a consideration when you're weighing what is better for you, a will or a trust. So there's different options. Also, if you have properties that have mortgages, you may want to look into how those should be owned and how those assets should be passed along to your heirs. So you may not want to move your property into a trust if there's mortgages and if it's not homestead. But there's a few factors, but definitely get that special needs trust. And definitely when you're working with your financial advisor, use that beneficiary form and you list the trust and you list the taxpayer ID number with that trust in place of your child's social security number for the amount of the inheritance that you want your child to have from that particular asset. So how does one set up a special needs trust that can be pointed to by Wendy? Well, I have a slide later, but it's like, what is more preferred if you create a special needs trust as part of your will, where you only create the trust gets created upon your death, or if you have a standalone document and create your trust for your for your child, let's say today. Well, I recommend that you create the standalone special needs trust as soon as possible, because you can use that as soon as it's set up, it's executed, and it has its taxpayer ID number. And that's what you take with you to the bank to open up bank accounts. That's what you take with you to Consolidated Planning Group to say, okay, this is what's going to be used in my beneficiary designation forms. You can't do that if you're not going to create your special needs trust for your child until you pass away. So nobody can use it. But if you have it already in existence, not only you can use it, but this is when you start talking to your friends, your family, grandparents. You tell them, hey, I have this trust already created. Here's all the information. Do with it what you will. So I suggest you contact an attorney. And if you do contact an attorney that does deal with trust, make sure they have experience with special needs trust, also known as supplemental needs trust. There's third-party trust. There's first-party trust. I had a gentleman come to me with a first-party trust, thinking that was sufficient for his wills, and it's not. So even though it was an attorney that drafted it, they didn't have the knowledge that they needed to have in order to create the right document.
Exactly. And we also like for people to have their standalone special needs trust, because what happens if, grandma or grandpa passes away and they've left money to your child's trust, or they want to leave money to your child's trust. That's the very, very best way. That's the ideal way for this to happen. Now, if they leave money straight up to your child and little Johnny gets an inheritance from grandma, straight to him. We can put it into a first party special needs trust, but there's a Medicaid reimbursement clause to the first party trust, which means, once your loved one passes away, if there's money left in that account, Medicaid can come back and claim reimbursement for those funds. Um, and it's not that we're not grateful to Medicaid, but we don't really want to leave them an inheritance. We would rather leave that to our family members. So that's why a third party trust is really the ideal situation. Now, it's not enough to just say these things in your will. You have to, have those beneficiary designation forms filled out. You have to get it set up. An attorney will set up the trust and set up your will, and then we can help you invest that money that's in the trust. Because Leona, can you help me explain? The trust is really just the titling legally of how that money is held, right? It's not, people think of it as an account or as a place, and it's not necessarily that, is it?
It's not. Think of it like it's like its own entity. So what I do, what happens is I have typically parents that come into my office, and I have already drafted an agreement. And so in the trust agreement, the parents are the grantors. They grant $100 and other good and valuable consideration to create the trust. Then the parents typically are also the initial trustees. They're the managers of the trust. Well, the trust can sit empty. It doesn't have to have anything in it. Again, you just point to it with your financial assets. And the parents are the initial trustees. And then, of course, your child with special needs is the initial beneficiary. So it is a document that we create, we draft, the attorneys draft. The attorney can help you get the taxpayer ID number. And then that is its own like entity. And that is what you use. Mhm.
It's hard to think in that way for some people, I think. Yeah.
So some people think, okay, well, my trust fund. Well, the trust can own a bank account where the funds are sitting. You would rather have investments properly advised to you by consolidated planning group. But we would also say that the trust can own the house that your child is going to live in. We had some questions earlier about how can I support my son to own his own home? Well, you don't want him to have assets that exceed the value of $2,000, even though his residence could be not counted towards eligibility determination by SSI. You still don't want to have the house eventually end up subject to MERP, Medicaid Estate Recovery Program, like you were just saying, where Medicaid can come back after your child passes and recoup some of their money that they've spent on your child's medical bills during their lifetime. So put the house in the name of the trust. You, as the parent, will sign the paperwork as the trustee of the trust. So you would be the one, you in your role as trustee would manage the assets of the trust. And the trust can own vehicles, bank accounts, life insurance policies. The trust will be the owner, not your child.
Perfect. I did see a question in the chat box, and before we get too far away from that conversation, we were talking about SSDI and RSDI a little bit. Before we get too far away from that, someone is asking if that is counted as earned income. It's not the same as SSI. So SSDI and RSDI are not counted against you because of something called the pickle amendment. That's like pickles, like you put on your cheeseburger. Basically, it says that if you're already receiving Medicaid and your amount of survivor or RSDI or retirement or whatever benefits, however you want to refer to it, If your benefits push you over the Medicaid limits, you get to keep Medicaid. That's called the Pickle Amendment. Okay, so you've all had a chance to kind of look at this page. Financial advisors can help you with needs analysis, looking at risk management, protection plans. We can manage your assets. We can set up ABLE accounts, help you with transition planning, provide advocacy. We can talk to you about appropriate funding sources and where on earth are you going to come up with all this money that your kids are going to need. We can strategize on those benefits like SSI and Medicaid, SSDI and Medicare. And we can help you with your Social Security to maximize all of the benefits that you and your family can get through Social Security. Leona, do you want to talk about this slide, please?
Sure. So my role as the attorney is to provide you with sound legal advice and prepare the documents that you would need in order to strategize properly to protect your child's eligibility for benefits, lifelong benefits. But we also help with deeds and the mortgages and leases and reviewing these documents, but trust instruments are definitely what we would want to prepare, and then use that trust document to make sure that we're deeding the property properly to the trust, or we are looking at maybe you have an extra house where it would be a rental house and you would have rental income. Well, you don't want your child who's on government benefits to receive rental income that would count against them and possibly get them disqualified for benefits. So the trust would be the owner of that rental property and receive the rental income. So there's just different types of strategizing that you would want to do with an attorney who has not just an idea of how to draft a deed or how to draft a trust, but also how it works together with the rules of SSI and making sure that these children are protected for the rest of their lives. And again, not every attorney understands the ramifications of what something will do to possibly injure or have a problem, create a problem for somebody's inheritance. I was reviewing, for example, a will for a grandmother who wanted to definitely leave money for her one of her grandchildren who had autism. And so in her will, she had a contingent trust provision to create this special needs trust for her grandson upon him being a beneficiary. And he was like second successor beneficiary. So she paid money, extra money, I'm sure, for this will and to have these provisions for special needs trust, but it would never be created unless, two other people had passed before she did. And so the intent was good, but the delivery was bad because it just really wouldn't be successful in creating the protection that she wanted for her special needs grandchild. So what you would have wanted to do, and what I would have recommended, is to have a third-party supplemental needs trust created as a standalone document. And then everybody can use it who wants to leave funds, inheritance, stocks, or any type of asset of value for the benefit of this child with special needs. So there was a question about if you have a trust created in Texas, is it gonna, you move states, is that gonna be a problem? So the trust law does vary from state to state, but we also recognize other states' legal documents. So you're not, I would say that you're going to be able to utilize your trust from Texas when you move to another state.
But you would probably want to have, someone in that new state just review it for you, right?
because you have SSI, which is, you have different government benefits, which are federal based, but they also work in conjunction with the state. So there's different states have different rules, and they may address different situations differently than another state.
So I see one more question that I can answer. Well, two more questions real quick, and then let's get back into the slides. Nancy wanted to know, are trust taxes more extreme than regular taxes? And yet, yes, Nancy, there are big tax differences. However, you're talking to a financial advisor and an attorney. You're not talking to a CPA. We do have a CPA. We have two actually that we know that focus on special needs topics. So if you want a referral, we'd be happy to send you over to one of our CPAs. We've also done webinars with them in the past where that question might have come up. So you can check our YouTube channel for that. And then finally, my son recently received back pay from SSI. Is that going to count against him? That's going to put him over his $2,000 limit. So what do I do with that money? You can put it into an ABLE account. You can use it to pay for things. You can spend it. You can put it into a trust. The other thing to know, though, is that when SSI sends you that back pay, they understand that they're doing that to you. And you have 9 months to spend that money out of your account before they'll count it against you. And if they split that big payment up into multiple months, you have 9 months from when it hits to spend that chunk of money. It's probably better just to go ahead and get it out while you can, put it into an ABLE account or something else, but you do have time that they don't really tell you about.
And a lot of people, if your child lives with you, remember that Social Security or SSI is primarily for food, clothing, and shelter. And so a lot of people need to understand that they should be receiving rent from their child who is an adult and lives in their house. That would be the shelter portion of the SSI funds that they're trying to spend assets on, or they're trying to spend the money on certain expenses. So if you don't have your child paying rent, you could risk losing a 1/3 of your child's benefits, monthly benefits from SSI. So when you're talking about getting that catch-up check from Social Security or SSI, if your child has been 18 for a while and should have been paying you rent during that period of time, you can say that you have loaned your child the room and board or their fair share of the household expenses that would be payable to you as the landlord out of SSI, that you were loaning them that money until their check came in. And that is where you would be able to transfer those funds to you, the parent, as the landlord. So that's another way where you can spend that money, and then you spend it, it's yours. So you spend it however it is that you wish. There are no restrictions on it, like there are restrictions on how you can spend the SSI funds. So guardianship, we do plenty of guardianships, but it's typically a guardianship of the person, especially with our younger children. We don't want to do guardianship of the estate because we don't want them to have an estate. We want the kids to have lesser restrictive alternatives to guardianship of the estate, which would be the supplemental needs trust. We want them to have any savings in, like Michelle was saying, the ABLE account or the any bank account that the trust would own. So we can avoid guardianship of the estate and only focus on guardianship of the person when your child is transitioning into adulthood. Power of attorney is another lesser restrictive alternative to guardianship. Your child would need to be able to understand the contract, the power of attorney that they are signing in order for it to be effective. So that is a question that I would leave to the doctor, who can perform an examination to see whether or not guardianship is warranted. If guardianship is not warranted, and at your ARD meetings at school, if they're not really discussing guardianship as a necessity, then you may be able to get by with something like a power of attorney or supportive decision-making agreement. SDMAs are are good because what they do is you have autonomy for your child with special needs, where they make the ultimate decision, but only after they talk to their decision makers or their helpers, whoever's supporting them. So the typically that is mom and dad. So before your child goes off to sign a lease at a new apartment, they have promised under this SDMA, before making that major decision, to talk to you first. But they ultimately have the right to do whatever it is that they want.
So really, the supported decision making is not legally binding, is it? It's more like a gentleman's agreement, if you will, correct?
Yes, you're not going to be able to throw that deep, but I have seen people, what you do where SDMAs, yes, it's just he or she promises to talk to mom and dad first. Where I've seen it where it is helpful tremendously is under school situations and at doctor's offices, where in the SDMA, your child has memorialized that they want, because they're relying on mom and dad for help in making decisions, they want their parents to still have notices for upcoming ARD meetings. And in the medical field, they also can include instructions that they still want their parents to have access to their medical records and to be a part of the decision-making process. And so they're putting their doctors and medical providers on notice with that SDMA. So that is helpful, but it's not going to force your child to come to you before they sign a lease, and you're not going to be able to undo the lease if they've signed something without talking to you first.
Perfect, perfect. Do you want to go over this slide for us, Leona, or
So
do you feel like we've kind of...
we've talked a lot about this, but let's see, analyzing your personal circumstances. Okay, for Medicaid and Social Security regulations. So Social Security administers Medicaid, SSI. So the Social Security Administration is who would be in charge of looking over the different rules and seeing what applies to your situation and what your child is eligible for. So we would want to know, SSI, we were saying probably won't be something your child would be eligible for before they're 18, because Social Security will look at household income and assets when determining eligibility. But when your child transitions into adulthood, then Social Security looks at your child's income and assets. So we would want to look at those types of circumstances and see what is your child's age, what are the assets and income that your child has when they're applying for these benefits. And hopefully the assets are minimal, but future assets can be put into the third-party supplemental needs trust. So that's what our planning is for. And we want to customize these different approaches to the different circumstances that our families have. Let's see. So for people in Texas, I talk to people, parents to sign up for your texasbenefits.gov. That is a good website to go ahead and open up an account for your child. If your child is still on the waiting list for Medicaid waiver programs, you can track where your child is on the different list on that website, and start looking at different benefits. Then there's also, there was one, how to apply for SNAP benefits for a disabled child was Rodolfo's question earlier. And so that, I believe you can apply for SNAP and other benefits like that on your texasbenefits.gov.
Perfect. Perfect. Let's see, what other questions can we, I'm trying to, put these topics up, but we're having such great discussion. I'm also watching the chat box to see if questions are coming up as people see these slides. So what happens if you work with someone like Leona, hopefully someone super smart like her who knows what they're actually doing, and if you work with someone like Consolidated Planning Group, the advisors and the attorneys should be able to work together to help you implement your plan. Now, we don't often, talk to each other. It's you talk to your attorney, you talk to your financial advisor. We are covering you guys and making sure that everything is flowing smoothly for you. But we're going to help you work your plan and implement all of your planning needs and make sure, we're reminding you, okay, did you call your attorney and get this set up? And your attorney is reminding you, okay, did you call your financial advisor and have them do this? So we're all, on your team, and we've all got your back. Oh, Leona has her website here that you could go and order. Is this a book?
I do. I have something where you can look at it, and it's those 8 steps that we were talking about. We go into a little bit more detail on where parents can go to get more information. And then on my website too, we have access to archived newsletters. We have different posts that people have asked questions similar to what we have today on our website. And we also have a YouTube channel called Attorney Phyllis, one word, where we have some of our videos here on YouTube.
Perfect, perfect. Yeah, we have our YouTube channel. There's all of our webinars are over there. So this is all about how you can contact Leona and the Phyllis Law Firm. Her email is there, the website, even the Calendly link, so that you can go ahead and set up a free 30-minute initial consultation. Is that on Zoom, Leona?
So we understand that some families can't leave the house, or it's very difficult for them to. So we offer these consultations either in person or over the phone or by Zoom, whatever's easiest for the family. And then we, of course, we give them the 30-minute consultation to discuss, a little bit about what their needs are and see if it's a good fit for both of us. And then we move forward with whatever services they'll need.
Perfect, perfect. So anybody who has additional questions for you that maybe they didn't want to put it out there in public, or maybe they did and we missed it, they didn't get to that question, they can just give you a call, send an email, even schedule that consultation with you, ask those quick questions, and then find out, if they want to work with you going forward. And it's kind of the same exact thing with us. We offer the same kind of free initial consultation. It's on Zoom. You can ask about any questions you might have. We want to learn a little bit about your family, and then we want to talk to you about how we work, what we charge as a company, and again, see if it would be a good idea for you to work with us. So it seems very, very similar. And now, Leona, you are you only work with people who are in Texas. Is that correct?
It is right now. I'm getting my license back in North Dakota.
Oh,
Um,
fun.
yep. So I'm going to go ahead and start talking to families in North Dakota also. There seems to be a big need for special needs attorneys in that state.
Okay, okay, great. Um, so anybody who wants to make an appointment for a consultation with Consolidated Planning Group, you can use this QR code, call or email the office, or call or email me personally. I've put my information in the chat box. There's also links here to our YouTube channel, Instagram, our podcast, and our Facebook page. And when you receive these slides later on today, those links will all be clickable. So you'll be able to go to those resources if you'd like. Let's see. I think Chris, I see one more question from Chris about what are the ways an independent adult who is receiving SSDI can easily benefit from funds in a special needs trust. In other words, how can we make it easier for both the beneficiary and the trustee? Well, you do have to have a trustee, and the beneficiary does have to kind of always go through the trustee, right, Leona?
Are we for a third party trust? Yes. So you are we talking about what types of expenses? Because I think that one of the things that we would like to know is where should we draw our funds from? It would depend on the type of expense it is. So
Mhm.
you might have a special needs trust. You might have also a 529A able account. You might have just SSI. And so for this independent person, they would want to kind of first see, um, is this a type of expense that needs to come from SSI? And then they would go through the rep payee first, right? And then if it is an expense that is allowed through the ABLE account, then you would want to work with that person who is in charge. But
Yeah.
special needs trust, the trustee should be on top of paying for allowable expenses. So, if it's something like medication or medical equipment that's not covered by Medicare or Medicaid, then the beneficiary should be able to reach out to their trustee to get that expense paid for. There are other expenses like furniture or home appliances or school or tuition at camp. There's cell phones, certain internet access. Those are expenses that can be paid out of the special needs trust. So in some cases, when parents come to me to draft their special needs trust agreement, they're the initial trustees. So it's contacting mom or dad. If it is
And you said mom or dad, so both of them can be on there.
yeah, you can have co-trustees. And then you also but there are situations where instead of a family member or friend, it is a corporate trustee. And so then you have to definitely petition for your funds and go through whatever their internal process is.
Yes, perfect, perfect. All right, so we are running out of time today. Chris and Penny still have some questions? Maybe a beneficiary uses a credit card, a bank account in the special needs trust, then automatically pays balances to the credit card. Is that acceptable by law?
Not sure about that one.
Yeah, because the whole point of having a trust is having that trustee to oversee things. And if you are, you're trying to get around that, it sounds like that would create problems and kind of negate the whole purpose. Chris, definitely please set up a consultation with us or with Leona, and we can help you walk through these. And then Penny wants to know, do withdrawals from the special needs trust for qualified expenses count as earned income for, no, it does not count as earned income for SSDI or anything. It is not earned income. All right. Unfortunately, we are out of time for today. Thank you all so much for taking the time to be here with us today, especially you, of course, Leona, for giving all of this fantastic advice. This is our entire team at Consolidated Planning Group. We look forward to talking with you and to working with you. And hopefully you will reach out to either us or to Leona if you have any questions whatsoever. We love being here and being able to help you. Please tell your friends and family about us and help us spread the word and the education that we offer, right? Thanks a lot, Leona. Thank you,
Thank you
everybody,
so
for
much.
being here. Bye-bye.